A very happy Thursday to everyone. It's a beautiful day here, and welcome to our second Advisors Forum of the year as part of our Elville webinar series. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's presentation. Today's topic is the 5-year hybrid trust, one of the most powerful tools in estate planning today, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. We have several new advisors on the webinar today, so I'll explain how this will work, and some from around the country far and wide. So welcome wherever you are, to our newcomers and to our frequent attendees as well. We encourage your general questions, so please note them at any time in the questions panel on your screen, and we will take time throughout the presentation to address them. Your questions always add value and help others learn, so don't be shy and send your questions to us anytime. You received the presentation slides yesterday by email for me to take notes if you wish, and the slides are also available in the section marked handouts on your screen to download at this time. For CFPs, CPAs, and many other professionals on today's presentation, you may receive 1.5 continuing education hours for attending today. And per my attendance records requirements, please, if I don't have it already, and if you have one, email me your ID number so I can submit your CE hours for approval and send out certificates tomorrow morning. Everyone will also receive a post-webinar feedback email right after the presentation. So please take just a few minutes to fill out this very brief survey to offer us your thoughts about today's presentation. And if you have topics that you'd like us to see offered on a future advisors forum, please note them as well in the survey comments that you have to share with us. And briefly, as we have a lot to cover, I'd like to share with you an overview about our firm and share a proper introduction for Steve. So I'm going to share my screen very briefly here. You should be able to see that now. So Elville and Associates, we were founded in 2010 by Stephen Elville. We have several different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. Our mission, as always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. And we do focus on education a lot here at Elville and Associates, and we do that in several ways through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, or CCP as we call it here. We're one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville and Associates. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, presenting at many workshops for businesses and their employees, webinars, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year, so congratulations to Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. So if you'd like to learn more about how we work to make a musical difference in the lives of children each day, I would love to speak with you further about that when we have more time. But right now, we are going to get started with our advisors forum. And Steve is chomping at the bit to get started and get out of the gates. He's like a horse in the gates at the Preakness recently, ready to get started. So we're going to go ahead and do that. I'm going to share my screen with you, Steve, and have you be the presenter.
Thank you, Jeff.
Get you underway here.
Thank you very much. So I'm going to show my screen and get my slideshow started. Bear with me just a second as I do that. And here we go with my slideshow. So
Hey,
thank
looks
you
good.
very much for that introduction, Jeff. And I'm not quite sure whether I enjoyed the Kentucky Derby more or the Preakness. So I am getting out of the gate here. And good afternoon to everyone, and welcome to our advisor forum. I know you are very busy, and it's my privilege to be with you this afternoon. And we want to make sure that we're efficient and that we begin and end on time and value your time and also bring a lot of value to you. And with that, I want to thank Jeff again for helping me do what I do. And for you to support our advisor forum helps us do what we do. And all of the associates and staff at Elville and Associates help me to do what I do, which I'm greatly privileged to be here and to help clients. That's what this is all about in the highest and best way. And today we're going to talk about, the 5-year hybrid trust. Some people will call this the Medicaid trust or the Medicaid Asset Protection Trust. And the reason that I named this presentation the 5-year hybrid trust is because I think that this trust has multiple uses. And underlying every kind of idea, of course, there are ancillary things going on in the background. And surrounding this whole notion of asset protection in the long-term care context, there are a lot of undercurrents going on. There's a lot of anxiety with clients and a lot of how are we going to pay for long-term care. I was just on a web-based call this morning with someone who has these very questions about parents in Florida. There are real how do we pay for the cost of care situations that you're aware of. There are situations where people are fortunate and smart and they got good advice and they have long-term care insurance. And there are people who have wealth such that they don't need to worry about such planning. But right there in the middle, the moderately wealthy client to the modestly wealthy client, these are the kinds of clients that many of us deal with. Of course, we may have wealthy, very wealthy clients, and we may have not so wealthy clients. But these moderate or middle of the road or middle rich clients, they are going to have the same needs as some of our more modest clients of modest wealth. So it's my goal here today to really give you a set of tools. These are tools that you may not be aware of. These are tools that you may be somewhat aware of, but you didn't know how to go forward or to advise your client properly. And what we're going to talk about today is not for everyone. There are people that this kind of approach in protecting assets for whatever motivation this person might have or this family might have, this solution may not be appropriate. So this is not a one-size-fits-all situation by any means, and we're just going to work through it and we're going to learn. And we're a resource for you. We're here to answer questions. And I want to thank not only the advisor friends, our financial advisors and CPAs and insurance professionals and others who have been so faithful and such good friends of Elville and Associates all these years, but I also want to thank those of you who are new, and I hope to meet you someday. All right, and the last thing I'll say before we get started is I wish everyone a very happy Memorial Day weekend ahead, which is always very exciting. So with that said, let's get started, and we're going to talk about, what is this 5-year trust and what is its history? We're going to discuss this in a little bit of detail so that you have a framework to think about. We're also going to talk about general concepts of these types of trusts. Why would somebody think about a 5-year trust? What is this? Federal and state law, we're just going to briefly touch on that. I know we're not talking to a group of lawyers today necessarily, although some of you may be lawyers. We're going to talk about the grantor trust rules. And so for those of you who really sit and think about a lot of tax law issues, you know that trusts are either grantor trusts, where the grantor of the trust pays the tax, or the trust itself pays the tax, where it's a non-grantor trust. We're going to talk about that as it relates to a Medicaid or 5-year trust. We're going to talk about the trust itself and how those types of trusts are built and why they're built that way. We're going to talk about nuts and bolts of the trust. We're going to talk about nuances, and we're also going to talk a little bit about the administration of this trust during the grantor's lifetime. Now, this is very important because those of you who may have clients that this trust is a solution for, this trust is handled a certain way during the grantor's life and at their deaths. And then maybe most importantly, I'm going to give you some examples. And these are real life examples. I'll talk to you from the heart about these examples that hopefully will hit home to some of your client situations and things that you've dealt with. And hopefully we will have plenty of time for questions and answers. So I'll try to be efficient. And speaking of that, if you have a question or concern during the presentation, please let Jeff know, and he will not be shy at all about stopping me or interrupting me if there's a question. So please don't hesitate. If you have a question, we will stop along the way to answer questions. So in the early days, and what I mean by this, the early days of elder law, what am I talking about there? Well, elder law is a field of estate planning that really focuses on not just the disposition of assets and not just on estate tax avoidance and so forth and gift tax issues, but it really focuses on long-term care, housing, special needs, nursing home placements, payments for long-term care, independent living, continuing care, retirement communities, everything you can imagine having to do with disability, aging, and long-term care. And that started in the early 1990s. Well, somewhere, in my opinion, around 2005, there was a revolution in the use of trusts in Medicaid planning. And back then, there was a lot of issues. There were issues about clients that want to do this kind of asset protection. They want to divest assets. Now, this could be a, quote, typical elder law client, someone who had maybe $300,000 in a house. But then 10 years later, my experience was that this might be a person that has $2.5 million in a house as the markets exploded. And people have the same issues, but they have just different asset levels. But the issue there was, how do we deal with the issues of giving away assets? And when you think about that, someone who is really motivated to do such a thing, to give away their assets or divest their assets, we would say, they would have a series of problems. Well, first of all, they would lose control of those assets. Second of all, if it was non-cash distribution, such as low basis stock or other investments or real estate, they would lose the cost basis adjustment at death. They would make a transfer of assets to beneficiaries, not only lose control, they would lose the cost basis adjustment. There was legal uncertainty because we had what is called the Deficit Reduction Act of 2005. So prior to 2005 and 2006, the look period, or the look back period, as many of you may recall, was 36 months, 3 years. And the rules relating to gifts for Medicaid purposes were different. Then in the George Bush II, so to speak, their administration in the mid-2000 area there in 2005 and 2006, there was a new law called the Deficit Reduction Act. And that Deficit Reduction Act changed the look period to 5 years, to 60 months and not 36 months. So not only that, but how gifts were treated was changed. And we don't have time to get into that kind of discussion today about what actually changed there, but there was a lot of uncertainty. So asset protection in the long-term care world was seen as something that was paramount. However, in traditional types of planning, there was no flexibility for changing circumstances and a loss of control. So a good example of this would be someone would come in to see a lawyer back then. They would say, we're very strongly motivated to divest ourselves of assets, and we really didn't have a lot of good solutions. The elder law bar didn't really have a lot of sophisticated thinking about this. So one solution that I saw many times back then was basically transferring assets into an irrevocable trust that was what I would just call a plain vanilla traditional irrevocable trust with a loss of control, loss of cost basis adjustment, all of those things. And that is sadly what was done a lot. But there was a change or shift, and that's what we're going to talk about today. We don't want all of these negative issues when someone is divesting assets, and fortunately, we now do have a way to deal with that, and that's what today's workshop is about. So what are clients looking for? Well, of course, clients are looking for various things. And all clients that are seeking advice and planning, it should be goal driven. They should know what their goal is, or we should help them develop what their goals are. And many times in the world of estate planning, not just in elder law, because these two areas for the moderately wealthy client, these two areas have a way of kind of diverging. And so what they're looking for, in my opinion, is people are generally looking for traditional estate planning, how to dispose of assets, how to do routine traditional asset protection, how to deal with the best income tax issues that we can provide as far as strategies. But many moderately wealthy clients are going to have subconscious concerns about divestment of assets and asset protection for long-term care. You know as well as I do, most of these folks have not planned for long-term care. They don't have hybrid products. They don't have long-term care insurance products. And so many times in traditional estate planning discussions, it will kind of morph into an elder law consultation. So this elder law consultation is an opportunity to provide value. And many times this conversation will involve a Medicaid trust. Now, I'm going to say again, before we get involved in this, that many times this is not an appropriate type of situation. There's lots of ways to do, or some ways at least, to do asset protection for long-term care without using a 5-year trust. But the 5-year trust, in my opinion, is not only for the right person, but it provides for the most flexibility in this kind of strategy. So let's just get one thing in our minds. It takes 5 years under the current law. It takes 5 years to get past the look period. Someone must divest assets in some way. There's a few ways of doing it, but someone must divest assets for long-term care purposes if they wish to put that asset out of reach of a Medicaid spend down. So that's what we're going to be talking about here. So the Medicaid Asset Protection Trust, or what I'll call the 5-year trust, was a creation of the elder law bar, in my opinion, about 2004, 2005. And it started in places like New York, Massachusetts, and other places where these trusts began to be used. And it's a hybrid trust. It is a trust that is an irrevocable trust in every sense, but it answers this question of how do I give away assets but retain some level of control? Now, we have to be very clear. There is definitely a divestment of assets, but the question is, does the grantor of the trust have any kind of strings attached? Do they have any kind of level of control? So with this kind of trust, the grantor can have some modicum of control. That's a fancy way of saying they have at least a little tiny bit of control. And the income only trust is one version of this Medicaid 5-year trust. So back when this was first started, these trusts were known as income only trusts. And if you Google this today and you do some research on it, you will still see that these trusts are called income only trusts. These trusts were designed to allow a grantor to transfer assets into a trust. So I like to use my hands and say, well, this is a transfer into this bubble, but the grantor is going to retain the income. So there's nothing wrong with that per se, but that is not something that we generally recommend today for various reasons. But it was called an income only trust because the grantor could divest the assets, but still retain the income. Okay, and I would say that today the use of these trusts is kind of central to estate planning and elder law practices, not only for Medicaid purposes, but for veterans planning purposes as well. But that's beyond the today's discussion. Again, all planning should be goal driven. And all planning for this kind of trust should only be done where the family situation is correct, the family situation is appropriate, the family members get along, and of course, any attorney or advisory team should really be driven in this particular context, I should say, by what I would call aspirational standards. And in elder law, we call these the NAILA aspirational standards, or the National Academy of Elder Law Attorneys. Very high ethical standards with regard to dealing with folks that are usually older in this context, and making sure that we are on the high and straight road, the correct path, if we are recommending these kinds of approaches. So with this 5-year trust, we are able to take advantage of what I would call the look period. Now, when we talk about this 5-year period, many of us call it the look back period. If we look back 5 years, did we divest assets? Okay, but maybe a better way of thinking about this for purposes of this webinar is it's a 5-year look forward period. For our clients, if they divest assets, just for example, this morning I was speaking to someone I mentioned, and we're talking about the parents being able to divest assets and look forward 5 years and say, can we get past this 5-year period? So that's what we're really talking about, the divestment of assets for 5 years. Now, when this person does this, whether it's a single person or a couple, there is not a total loss of control because the grantor retains certain strings, which we're going to get into. And it retains certain income tax advantages. The Section 121 exclusion from capital gain and the cost basis adjustment under Section 1014. These are things that are built in. Now I'm going to stop just for a second, and I always like to make sure that I'm setting the proper framework. What I just mentioned, the retention of these income tax advantages, is the main reason, other than the asset protection, it's one of the main reasons for using a trust and not just making an outright gift or outright divestment. Sadly, I reviewed a Medicaid trust that was drafted by an attorney some 10 years ago, and I just reviewed this trust in the last 3 years. And unfortunately, that attorney did not draft that Medicaid trust properly, and there was no cost basis adjustment at death. I reviewed the trust, another attorney reviewed the trust, 2 CPAs reviewed the trust, and there was not a sufficient provision in that trust to cause the cost basis adjustment at death and other income tax advantages that are essential for a Medicaid trust. So drafting this kind of trust and making sure that the client is getting what they are trying to do, they're accomplishing what they're trying to do with this trust, is critical. One of the features of a 5-year trust is the creditor protection for the potential creditors of the beneficiaries. So imagine this bubble, this circle that I'm drawing with my hands. The assets of the grantor are transferred to this bubble, and now there might be, let's say, 3 children who are the beneficiaries of this trust. And remember, the grantor cannot be a beneficiary of a Medicaid trust. They have transferred their assets to this trust, okay? They cannot, under any circumstances, be someone who could obtain a benefit from this trust. So that's a very, very big issue. But now we have, let's say, 2 or 3 or 4 children. They are the beneficiaries of this trust. What if one of those children has a divorce or a car accident or a bankruptcy? One of the features of the Medicaid or 5-year trust is that the trust is protected from the claims of the beneficiary's creditors. This is one of the big issues because mom and dad, or whoever the grantor is, they want to make sure, and I have an example for you at the end here, they want to make sure that if they transfer assets and divest assets, that these assets are protected from the claims of the beneficiary's creditors and can't be lost. So this is a very situational thing. It's based on client needs, and my practice, or our general practice, is if we are creating a Medicaid trust, then we also probably are going to create a revocable trust, because remember, the 5-year trust, it it avoids probate. That's one of the features of it. Just like a revocable trust, it would avoid probate. So we don't want to have someone's assets avoiding probate here with the 5-year trust and not avoiding probate over here. So we always at our firm, where it's appropriate, we use a 5-year trust and also a revocable trust to make sure that the grantor does not have probate. Now, this 5-year trust is not the only solution. I mentioned earlier that outright gifting could be appropriate. Let's say that someone has an only child and the divested assets are really just going to be cash. Those cash assets do not have a basis. Well, maybe there's no need for a trust. This is all going to be situational. But again, there are income tax issues, there are control issues. Okay, so our client divested assets and put it into the hands of a child, did not use a trust. Well, now, of course, it's a completed gift for IRS purposes. So that child now has that money and they can do whatever they want with it. Now, of course, in most appropriate situations, that's not going to happen. And that trusted child is going to do the right thing. But what if that child now gets divorced? What if that child has assets that are now subject to an IRS lien or a bankruptcy or a car accident where someone is suing them? So this control issue is very important, even if we trust the child implicitly or the parent trusts the child implicitly. And then, of course, there is a concept of a life estate deed. So it is possible to divest a piece of real estate and start the 5-year period, the 5-year look period, by simply using a life estate deed, where a grantor reserves the power to live or the right to live in the property forever, but they are starting the 5-year period the moment that they give up the power to sell. So a life estate deed with no power of sale, Medicaid considers that to be a divestment of asset to the remainderment, and that starts the 5 years. But what you will find is the life estate deed is fine in some circumstances, but it does not provide for the flexibility that most people would want if they're going to divest assets. So as we continue to go through this introduction and general concepts, we're going to continue now to drill into the disadvantages and potential problems of using an irrevocable trust, a 5-year trust for these purposes. So family dynamics could be very, very problematic. Going back to someone again that I just spoke to this morning, there is a little bit of a family dynamic that concerns me about using a 5-year trust, but we may be able to overcome that. I don't know. In some families, it's very clear that even though the grantors want to divest assets, that this kind of trust may not be appropriate because we don't have family harmony. So that's important. The complexity of the trust may be a disadvantage. The assets of the trust, the assets that are going to be transferred to the trust, or the person that they wanted to transfer certain assets, these assets may not be appropriate. For example, someone is heavy in IRA assets and they want to divest those assets. Well, we can't put those assets in a Medicaid trust because it's going to trigger taxation on the cashing out of that IRA or on the transfer of that IRA to a trust. So some assets are just not conducive. It is possible to put a non-qualified annuity. If it's carefully handled, it's possible to do that. It's even possible to put savings bonds into one of these trusts, but we have to be very careful with certain assets when they're transferred. Maintenance and upkeep. Some people should be maintaining and upkeeping this trust, and some people do and some people don't, but that is an issue and it's a potential problem. Now, if we are starting the 5-year period, there's usually not a lot of maintenance, but we want to build flexibility into the trust design because of potential changes in the laws and potential changes in the Medicaid world. Client security and peace of mind. No matter what an advisor or a lawyer will talk to a client about and how wonderful this strategy is, it's not going to work if the client doesn't feel good about it and doesn't have peace of mind about it. I spoke to a client recently whose children urged her to do a Medicaid or 5-year trust, but she wasn't so sure that she wanted to do that. And it only was after some careful counseling that she felt good about it and said, yes, I want to do this. In my own family, I have had people that the 5-year trust would have been perfect for, but they did not feel that it was appropriate for them. So we have to recognize that. And we also have to take into consideration when someone divests assets and they start this 5-year period, what is that person's health and what is the real possibility of being able to get past the 5-year period? And some of you today are going to have the right questions, and that is, Steve, what happens if we don't get past this 5-year period? What if clients want to start this strategy, but we don't get past that 5 years because we don't have enough money, or we don't have the health, we have a health crisis somewhere during the 5-year period? We're going to talk about that today. Long-term care insurance can be a powerful tool. So speaking of how do we get past the 5-year period, when you think about it, if a person has long-term care insurance, this is going to be one of the viable ways that they can ensure that when they start that 5-year look period, if it's appropriate for them, that they will be able to get past that 5 years, even if they have a health crisis, because they've got that long-term care insurance. Now, one of the disadvantages, switching back to that real quickly, is improper design. The trustee powers could be too broad, the grantor's powers could be too broad, and the attorney themselves could overdraft the trust. I want to spend just maybe 30 or 40 seconds on this. There are many, many cases from places like Massachusetts over the years where hundreds of administrative law cases were conducted, where attorneys overdrafted these trusts, and they didn't follow the strict guidelines that need to be followed, where, remember what I said at the beginning, the grantor cannot in any way, under any circumstances, and there is such a thing as called the under any circumstances test. Under any circumstances can the grantor get assets back out of this trust. And many attorneys in places like Massachusetts were too creative, and they actually shot themselves in the foot, shot the clients in the foot, and created trust that the administrative agencies were able to challenge. But thank goodness, through all of those back and forth cases in other states, we are now pretty settled on what is necessary and what is acceptable in a 5-year type trust, where we are keeping in the straight and narrow path for clients as they try to protect assets. So client counseling is primary, okay? Client counseling is primary to this. This is something that I would recommend that all of the advisory team be a part of. Now, of course, a lot of clients are going to come to the attorney. They're going to sit and counsel with the attorney about this kind of strategy. But I think it's something that all of the advisory team, the financial advisor, the CPA, everybody should really be on the same page and understand what the client is trying to accomplish. Client education, the continuing education, is really important, because conceptually the client will understand what they want to do here, but we have to continue to educate them so that once they have this trust in place and they're living with it, that they understand what they've got and what they've given up, and that they understand whether they have flexibility and how that works. And then third, and maybe just as important, is fiduciary education. So as we get into this, you're going to see that the children that are involved, or the lifetime beneficiaries that are involved, and the trustee that is involved, for the grantor here, this is the person, this trustee, and the cooperation of the children, this is what gives the grantor the flexibility and the peace of mind that they need to be able to actually divest these assets. So educating those fiduciaries and children is extremely important. So again, I'm repeating myself here intentionally. Jeff says we are redundant sometimes intentionally. Without proper trust and confidence in the fiduciaries, this trust is really fraught with a lot of issues, and we have to be careful that it's for the right client. Now, the trust protector is the key, is one of the key components of flexibility. And for those of you who are familiar with the trust protector, I apologize. I'm going to act like you know nothing about this, but the trust protector is a special fiduciary that is given the power to amend a trust or to change trustees, to remove and replace trustees, and trust protectors can be given other powers. So in my opinion, in a 5-year trust, the trust protector design, the fact that the grantor has a trust protector in there, this is one of the big features that gives the grantor the peace of mind that they divested assets, but still have this modicum of control and assurance that even if their chosen trustee or the lifetime beneficiaries kind of go off the rails and stop appreciating what mom and dad did for them, that the grantor still has this level of control through a trust protector, and we're going to talk about that a little bit more. Jeff, I'm going to take just a sip of water and see if anyone has a question yet.
Thanks, Steve. No questions as of yet.
Thank you. All right. Thank you for hanging in there with me. Now, I'm just going to touch on this briefly. For those of you who are very interested in this, the federal and state law on this really comes from the United States Code, Section 1396 in general, 1396P in specifically in that context, and a transmittal called HCFA Transmittal 64. This is kind of the basis of it for those of you who are really interested in drilling down into that. And in Maryland law, of course, we have the Code of Maryland Regulations and we have the Medicaid Manual. And the Medicaid Manual is now online. So I know a lot of our CPAs and advisors on this webinar are not going to necessarily be interested in this state and federal law citation slides here, but I just wanted to let you know where this is. All right, so having given you a little bit of background there, for those of you who don't already know a lot about these trusts, let's talk about who would potentially utilize this trust. And again, my goal is to make you aware of a few of the tools that are out there available to you. Recently, we talked about the uses of irrevocable trust and the general irrevocable trusts that are out there. We probably talked about 20 or 30 different irrevocable trusts, and this was one of them. So let's drill down into why and how these are used. So it can be used by a married couple or an individual. This is the person that we just described. This person is trying to be proactive about shielding assets from being considered an available resource for a Medicaid spend down. Now, think about this for a second if you haven't had the time to think about this. If we are dealing with a married couple and only one of those two spouses goes into a long-term care nursing home and they had no long-term care insurance, that well spouse can preserve all the assets through a proper counseling, proper strategy, proper Medicaid spend down. What we're really talking about here is divesting assets that will be protected for both spouses potential long-term care issues, or for a single person. All right, so that's what we're talking about here, being proactive ahead of time to divest assets for long-term care purposes, okay? And again, that's my bullet point here is the second one. It's for both spouses and not just one. It's to maintain this modicum of control over the assets. And it basically establishes what I would call this unspoken or tacit agreement between the grantor, which is usually a parent, and the children who are the lifetime beneficiaries, that this money will be transferred, it will be preserved, hopefully, if the strategy works. But if the grantor needs those assets back during their lifetime, that those assets will be gifted back to them out of the trust. Now, before you get confused, this does not mean that it will be distributed back, but it will be gifted out, and we'll talk about that a little bit more before we end today. And this is the flexibility that is built into the trust. And this last bullet point, we want to be able to do all this to be able to gift the assets away for Medicaid purposes, but have a different strategy for IRS purposes. And one of those strategies is to maintain the cost basis adjustment at death. In the example I gave earlier, where the attorney had failed to put in the provisions necessary for a cost basis adjustment at death, there were 5 properties with a very large appreciation and a very low basis generally for all the 5 properties. And at the grantor's death, there was no step up in basis. So that's a big problem. And that's one of the big things we always want to make sure of in these trusts. Continuing now, the grantor wants to control, okay, whether or not they are creating a certain type of strategy or maybe creating a different type of strategy. In other words, the grantor needs to be intentional. Do these gifts represent a completed or incomplete gift? And do they retain the right to live in the residence and so forth? Do they wish to retain the design control? Now, generally, these trusts will be grantor trusts. These trusts are generally trusts where the grantor continues to pay the income tax on any income, regardless of whether they receive it. And here the next bullet point is that grantor can potentially receive income, but we recognize that, or recommend, I should say, that the grantor does not retain the income. Now, why? We've talked about this a couple of times. Why would we recommend that, generally speaking, the grantor not retain the income? Well, remember that on a practical level, we're trying to get past the 5-year period. Now, if we get past the 5-year period, which would be a great win, now, if the grantor applies for Medicaid in the future, Medicaid will will not be able to put a lien on the property or not be able to say that these gifted assets are part of the grantor's estate for Medicaid purposes. But now if we have this income stream coming back to the grantor, that income stream would probably have to go towards the cost of care, but it also could cause scrutiny of that Medicaid trust. So there's just a lot of reasons why we would prefer that the grantor not be an income beneficiary. Now, with that said, there are going to be times when it's just necessary that the grantor retain the income, but it's something that we would prefer to avoid. As I mentioned earlier, one of the goals is to protect the gifted assets from the claims of the beneficiary's creditors during the grantor's lifetime. And then also, it could be designed into this trust to protect the beneficiaries from the claims of creditors even after the grantor's death. So in other words, this trust can have asset protection for beneficiaries beyond the grantor's lifetime and to avoid probate. All right, so thank you for hanging in there with me as we continue to go through this. So the client who wishes to engage in this kind of planning, again, should possess not only the goal, as I say here in the second bullet point, but they should possess the type of assets that will actually make this planning work. So let's talk about that for a moment. I would say the person that this works best for is a person who does not have to give away all their assets to the Medicaid trust. And we wouldn't want that. We would want the person to retain, or the couple to retain, a sizable amount of their assets. And why would that be? Well, number one, we want them to be comfortable. But number two, we want them to have enough money to be able to get through the 5-year period. So we're going to talk about that again a little bit more, but we want the idea being we can give this gift and we can start this 5-year period and we can actually get through it. Even if we have a health crisis, we have assets, or we have long-term care insurance, or we have an annuity, we have a way to be able to deal with the 5-year period. And of course, they need to understand the nature and the mechanics of giving away the assets, that they are actually giving them away, even though we are retaining a couple of powers. Now, for those of you who have been patiently waiting, I'll go ahead and tell you what those powers are. The grantor is giving away their assets in this trust, but they are retaining the right to change beneficiaries. They are retaining the right at their death. It's called a testamentary power of appointment. They are retaining the right to change the beneficiaries at death, that is one of the main reasons that they get a cost basis adjustment at death. They not only have the flexibility to change beneficiaries, which they probably never will, but they are also causing enough control in themselves that the IRS will say there is a cost basis adjustment at death. And they are also retaining, I should say, the right to change trustees. So we have to understand the nature and the mechanics. The client has to understand that they can retain some control. Let's give an example. The client says to their child, a year after this trust is created, we still have 4 years to go. The client says, I would like $25,000 back out of my trust. The trustee says, sorry, mom and dad, I knew you were going to ask that question, and I'm sorry, but I can't do that. Well, you see, that's just not going to work because that's not what the grantor signed up for. So the issue here is that the grantor or grantors, they have the right to change beneficiaries and they have the right to change trustees. And now with that leverage, it's very unlikely that that child would refuse to give some money back to the grantor if it was needed. Now, the next question you may ask is, Steve, how do you do that? How do you give assets back out of the trust to the grantor? Well, this can't be one of the purposes of the trust, correct? We don't want to signal to the world that this is one of the reasons this trust is being created. And by the way, that's what can happen with overdrafting by attorneys who do silly things and say certain silly things in these documents. So we want to stay away from that. But the actual mechanics are this. And if those of you are out there today with a pad of paper or you have a tablet in front of you, I will try to give you the lay of the land here with this trust after I've been talking so much about its design. So here we have this trust. The Medicaid trust has lifetime beneficiaries, the children, and it has death beneficiaries, usually children. So it doesn't have to be children, but even though I did one recently with grandchildren, it's usually lifetime beneficiary children, death beneficiary children that are the same. And it has a trustee. Now, once this trust is funded, there's a tacit agreement that this money will not be used for the lifetime beneficiaries, but it is there for mom and dad or the single parent who created this trust. Now, if that parent needs money out of the trust, remember that this trust is drafted where lifetime gifts could be made to the lifetime beneficiaries by the trustee. But the trust is designed where the trustee has the right to give away the assets or to distribute the assets equally among the lifetime beneficiaries or unequally. And that's a very important thing. So the trustee would distribute assets unequally. They would distribute assets out to themselves. And that distribution to that trustee is their money. It's a completed gift. That trustee can do whatever they want because they were one of the lifetime beneficiaries. But that trustee just happens to use that money for the benefit of the parent. So money can be distributed out to the lifetime beneficiary or beneficiaries, usually one person, the trustee, and that trustee will use the money for the grantor parent. That's how money is taken out through the back door and used for these purposes. So these are the mechanics of the Medicaid 5-year trust. So we have to have family relationships that are conducive. We have to have trustees and fiduciaries that are trusted implicitly. And we have to understand the potential risks associated with this and build flexibility in. And the flexibility is really built in with good thinking and good design up front, and with trustees and trust protectors that are implicitly trusted. Okay, I'm going to keep moving now a little bit faster. Thank you for your patience as we work through this. So success in Medicaid planning is defined as maybe one of these following examples, okay? So a grantor transferred his assets or her assets to this trust, but they never needed Medicaid. So let's think about that. There's lots of people who are never going to need Medicaid or long-term care nursing, even though there's going to be a lot of people that do need it. So what was the advantage here? Well, the grantor had peace of mind. They were able to transfer assets, maintain control. maintain a cost basis adjustment, and avoid probate at death. But they were planning for a pre-crisis situation or in a pre-crisis mode. Okay. Second bullet point here: the grantor transferred their assets to the trust, and subsequently Medicaid benefits were needed, and they were needed way after the 5-year period. So we accomplished what we were trying to do. Through this planning, the grantor was able to save 100% of the divested assets. And in that situation, we were hopefully in a situation there where the grantor had plenty of money set aside over here and not just the divested assets. But there we've saved 100%. And a third bullet point, I guess, would be here the grantor transferred their assets to the Medicaid trust or the 5-year trust, and the benefits were needed, but the problem was that those benefits were needed during the 5-year period. Now, this is perhaps a little bit beyond the discussion, okay? This is a situation that you're going to be thinking about if you haven't thought about it already. What if the grantor does not get through the 5-year period and they have a crisis? Well, this is going to be something that I would like you to think about as far as a continuum. This is when the trust was initiated, this is the 5-year period, and this is our goal over here. Well, if this crisis occurred in year 4 of the 5 years, probably the family, the grantor, the trustee would just continue on the course and then get past the 5-year period and then apply for Medicaid. Now, in that situation, that is what this bullet point is really illustrating. The grantor was not able to save 100% of the divested assets, but they were able to save a vast majority of the assets. So that is something we need to be aware of, that family harmony, see, at this time of crisis, we didn't get through the 5 years. That family harmony is essential. Now, let's take an even more important example. Let's say that the Medicaid assets, the Medicaid benefits were needed, but the crisis that occurred only a year or two after the trust was created. So now what do? Well, we have a crisis, and we're going to have to undo that trust because the family probably will not want to have to pay privately for the next 3 to 4 years because we had this crisis very early on. So the strategy did not work. Now, if we stop right there, we can see the need for family cooperation to be able to, in harmony, undo the trust, whether we had to petition a court to say the trust does not fulfill its material purpose, or through a common law termination of the trust where everyone agrees this trust is terminated and the assets are placed back into the name of the grantor, which may sound very counterintuitive, but there are other asset protection strategies that can be employed at that time. They may not be as good as the Medicaid trust strategy, but we know the Medicaid strategy for the trust was not going to work. We have to undo that. Now, the other thing that we can clearly see here is that if a family that engages in this strategy, if they have enough assets sitting over here outside of the trust, or if they have those assets in addition to long-term care insurance, now we know we do not have to worry about this. And if there's a crisis at any time during the 5 years, we are not going to have to undo the trust and switch to another strategy. So far, I hope that what I'm presenting to you today, you can get a little bit of an idea and a framework of how these hybrid trusts are used in flexible planning where someone wants to divest themselves of assets. We're not going to spend a lot of time here on the grantor trust rules. Just know that a trust like a Medicaid trust is usually a grantor trust, just like a life insurance trust is usually a grantor trust. But why would we have the Medicaid trust as a grantor trust? Well, we want it to be a grantor trust as to income and principal. We don't need to get into all of that, but we do want that step up in basis, and we do want the house to have that section 121 exclusion from capital gain if that house is sold, or that real estate or those assets are sold, specific to 121, the house is sold after it is transferred into a trust. One of the advantages of the 5-year trust is that real estate, for example, can be transferred into the trust to start the 5-year period, then it can be sold within the trust. And the money, the proceeds of sales, stay within the trust. This is very, very important because a lot of people are confused by this, and they think that if a property is sold, that now the grantor is going to have a lot of cash in their name and it's going to ruin the Medicaid planning or the asset protection planning. But that's not going to be the case, because through the proper application of the grantor trust rules and the design of the trust, the house can be sold after it is transferred into a trust and still have the same tax advantages, generally speaking. These are just a little bit of illustration here of grantor trust rules. I'm not going to waste our time on those, but I want you to see these important rules and where they are in the IRS code. And what is the application of the grantor trust rules to a Medicaid 5-year trust? Again, it's causing grantor trust status, and we're trying to cause a step up in basis, and we're trying to maintain that Section 121 exclusion from capital gain. So we establish a Medicaid trust, we implement it, and we fund that trust. It is designed as a grantor trust. The grantor can retain income. We don't recommend it, but you're going to run into situations where the grantor absolutely must, or maybe they have real estate and they are getting income from that real estate. They want to retain the income. The grantor cannot have any control whatsoever over the principal. This is the any circumstances test that I talked about. And typically we're going to have this as an estate inclusion. The assets of the trust are included in the grantor's estate. Remember, for the moderate to modest wealthy client, we're not really worried too much about estate tax, especially with the very large exemptions that we have now. And just as a review, we want that grantor to have a modicum of control through the special testamentary power of appointment to change beneficiaries, to change trustees, and so forth. Now, remember back to the beginning of the presentation when I said a grantor could be given too much power. An attorney could be too fancy in their drafting, too loose in their drafting. We want to stay away from a lifetime power of appointment. A lifetime power of appointment, it is generally thought to give too much power to the grantor to change beneficiaries during life, to change beneficiaries of the trust during life, a lifetime power of appointment. The concern there is that the grantor has too much power, and under review, the Medicaid trust might be deemed to be ignored and the divestment of assets ignored for Medicaid purposes. Trustee selection is huge. It's important. We have a trustee selection webinar tomorrow that we do on a quarterly basis. Nothing could be more important for flexibility. The trust protector, nothing could be more important for the grantor to have flexibility. And again, trust protector powers include the power to remove and replace trustees, to amend the trust administratively. Let's stop there for just a second. We don't really want to amend a Medicaid 5-year trust unless we absolutely have to. The idea is to get this 5-year look period in motion and to not disturb it. What we don't want is, if this trust was ever scrutinized, we hope it never would be, if it was ever reviewed, we wouldn't want that amendment to be something that Medicaid would say, well, that triggers a new 5-year period. So we have to be very careful with that, but there are times when the trust does need to be administratively amended for tax purposes or otherwise. And of course, a power to mediate disputes and other types of powers can be given to a trust protector. So the trust protector provides flexibility under changing circumstances. And of course, a trust protector could be appointed by court, but we want to stay away from that. And then for those of you who are not really that familiar with trust protectors can be appointed on a passive basis. In other words, no trust protector is actually appointed in the document, but the document says that there can be a trust protector. and that one can be appointed by someone or a court. I think in a Medicaid trust, it's important, as well as it would be in a special needs trust or other trust where we have an ongoing situation that is more serious. I think there should be an active trust protector, a person who is actually appointed, and a successor trust protector that the grantor actually names in the documents. And that can be a way for the grantor to have peace of mind that they've been a part of naming, and they should be a part of naming, who their trust protector would be. So again, we have lifetime and death beneficiaries. We talked about some of the mechanics and the considerations. We talked about the treatment of income. It's best if the income is not preserved, but it can be. And we talked about grantor versus non-grantor trust status. And just again, to set the stage, the Medicaid 5-year trust is, generally speaking, a grantor trust, but trusts for beneficiaries after the grantor's death, if the grantor were to do further asset protection for someone at their death, that is a non-grantor trust. Let's talk about the treatment of the residents. A lot of clients are going to want to transfer their residents into this Medicaid 5-year trust. And we used to be very concerned about this. And I think there is some level of concern about certain states, and I'll use Massachusetts again, and I'm actually going to give you some references to this if you're interested. And these states argued that the grantor is having too much of their cake and eat it too by transferring a residence into the trust and then retaining the right to use the residence during their lives without paying rent. And so there was quite a stir up until about 2017, 2018 about this issue. And we used to take other measures, like not putting the house into the trust, not retaining the right to live in the residence in the trust, but to use separate agreements. I think this is going to be a case-by-case situation. I don't want to take too much of our time about it right now, but I think that many of these issues have been resolved, and generally speaking, it will be okay, case by case, it will be okay to put the primary residence and reserve a life estate to the grantor and their ability to occupy the residence right inside of the trust, although every situation has to be looked at. And here you're going to see some of these references. I won't take our time on that today, about how this evolved over time and how these are currently treated. These are some of the Massachusetts cases that we in Maryland have tried to be very cognizant of, but we think until the next round of challenges, which we don't see coming, actually, we think that many of these trust design issues have been resolved, and we feel that cases in states like the Massachusetts example, these are indicative of what we need to draft for and how we need to be cognizant. And this is part of the counseling issue for any of our clients, that none of these strategies or no strategy is 100% safe or bulletproof. But based on what we know today, we feel that these trusts are purposeful and that they're effective in what we can do based on the current law. So I won't spend a lot of time on these cases that are just really for your reference. And what we are talking about here in this slide, again, is how many of these issues have been settled. So let's say that we have a grantor that's living in the house. They have transferred their property to the trust. They are comfortable living there. Everything is going fine. But now they have to apply for Medicaid. And let's say that even though Maryland is not an expanded Medicaid recovery state, let's say that Maryland someday started to scrutinize these trusts, which to my knowledge has not happened. Well, what would happen in the worst case scenario under Transmittal 64 is that the grantor might be deemed to have to pay more towards the cost of care based on an amount of rent they should have paid to live in the house, the fair market value of rent. But what was the worry was that the trust would be totally marginalized or set aside if it were ever scrutinized, and the transfer of assets, the divestment of assets, would be null and void. But that has been overruled, and the consensus is that the worst case that would happen, even if the trust was scrutinized by the state, and It would not cause an ineligibility for long-term care Medicaid, but it could require a payment of what the fair market value rental income would have been for the house. So that's kind of what we think is the worst case scenario, although we do not see that happening either. So we have to stay vigilant as not only attorneys, but as a team. We have to make sure that this kind of strategy is for the right person, the right family, and we don't want to be too liberal in our drafting and in our approach, and we don't want to be we don't want to have our eyes closed to the client's needs and their emotional reactions to having a trust like this. So we're just going to go through just a few more slides here, and I'm going to get to some questions and answers, and I'm also going to give you some examples. So the transfer of assets to the trust, again, as we start to get towards the end of the presentation here, we want to make sure this is a non-taxable event. We don't want to use IRAs and qualified plans, savings bonds possibly, non-qualified annuities possibly. We want to make sure that we have family harmony about how distributions would be made to the beneficiaries. We want to use a spendthrift clause. You're going to see what I mean by that in the examples. We want to make sure that the beneficiary's creditors cannot penetrate the trust. If a beneficiary is applying for financial aid for a young child of theirs, this being a beneficiary of this trust could cause a problem with that. So we want to make sure we understand that. A sale of the residence, we talked about that. That can occur inside of the trust. The trust can have a mortgage inside of it. It's a grantor trust, and there can be a mortgage refinance inside of this trust. There are mortgage companies out there that will do that. Property tax issues, we have to be very careful that we don't change the status of anyone's homestead exemption or property taxes when we transfer this into a trust. And basically, we just want to be thinking ahead. We want to, if we're using this trust, we want to make sure that we have a reasonable chance of success. And we want to know that the grantor and their children understand the risks and the fallback positions if we have to take a defensive position because they didn't get through the 5 years. And we want to think in terms of percentages of success. And then long-term care insurance as a tool. Strongly encourage that we continue to have clients purchase long-term care insurance or hybrids where possible as a tool to be able to get past the 5-year divestment period. Income tax reporting. This is a grantor trust. We won't spend a lot of time on this. Most of our trusts, we're going to want to use a tax ID number because we're showing the world, we're showing the outside world that this is in every respect a legitimate, irrevocable trust that the grantor has divested assets. So tax reporting is a little bit beyond today's discussion. Gift tax return. A gift tax return should be filed, although most attorneys do not do that. A gift tax return should be filed showing that the gift has been made, even though oftentimes the trust is drafted as an incomplete gift. And this will make not a whole lot of sense on this webinar, but just understand that the best practice in this particular area is to file a gift tax return. Maintenance and updating, we talked about that a little bit. Flexibility is the key. So we have to make sure that we build in flexibility, and when we maintain and update the plan over the years, we want to make sure that the fiduciaries that have been appointed are still viable, including the trust protector. All right, well, Jeff, I'm at 2:10, and I think we still have some time for questions, but I'm going to give the examples now before we go into questions. And the first example I'm going to give is what I will call the farmhouse Medicaid Asset Protection Trust. I had dear clients years ago, and they gave me permission to tell this story, and I, of course, will tell it anonymously. And the issue here has to do with asset protection, not only for long-term care purposes, but for purposes of the beneficiaries of the trust, the lifetime beneficiaries, and protecting the grantor. To make a long story short, a family transferred their beautiful farmhouse on approximately 12 acres into a Medicaid trust. This was done at another law firm, and I kind of inherited these clients when they were about 3 years through the 5-year look period. Well, again, in the interest of time, one of the trustees of the trust and one of the beneficiaries of the trust had a terrible divorce. That divorce evolved into a situation where the divorcing spouse, meaning the non-trustee divorcing spouse, attempted to, through the divorce court, ask for 1/2 of the trust property as part of the divorce settlement. So just to set the stage here, mom and dad had transferred their farmhouse into the trust. A divorcing spouse of one of the beneficiaries is asking the court to give her 1/2 of the house as part of the divorce settlement. Because remember, mom and dad have basically given away the house. The good news is that because of the spendthrift provision and because of the way that trust is designed, this property was protected. The trust property was protected from the claims of the divorcing spouse's, the creditor, basically the divorcing spouse. So that case, as far as I know, was thrown out as far as her asking for that property out of the trust. So that's the value of the grantor being able to transfer property to a Medicaid trust and have it exempt from the claims of the beneficiary's creditors, in this case, a divorcing spouse. Now, the middle rich client, this is the person we're basically talking about today. This is a person who says, well, you know, I'm fairly well off, but I'm not well off enough to really be able to finance 100% of my long-term care necessarily, and I want to make sure that I'm leaving my children a legacy. That person is the kind of person that will transfer assets into this trust, and that's the kind of person that we want to know. Over here, outside of the Medicaid trust, they have $400,000 or $500,000, just to use round numbers, and they may or may not have long-term care insurance, but these assets are going to remain over here no matter what is transferred into the Medicaid trust, so that we have assurance that they can get past the 5-year period. Now, the Hail Mary pass elder law client, in my example, is the person who does not enjoy the luxury of having those assets, and they come to an attorney and they say, my number one goal is to preserve whatever I have for my children or my child. And that's a very legitimate concern. But now the problem is this person doesn't necessarily have long-term care insurance. They don't, in my example, and they don't have enough money to really get through the 5-year period. So this person wants to start the 5-year look period, but they don't have enough assets to make sure they can get through that period. And they have certain assets they want to divest. So this is a very, unfortunately, common situation. And the person has to be counseled that, yes, we can do this kind of thing, but there's a high possibility that it may not work. So we have to understand that going in. And this is where counseling is an example. The bulletproof elder law client is a person who has lots of income. So they have lots of income. This is the person that you and I have run into that has $8,000, $9,000, $12,000 a month of fixed income. And so this person, even if they don't have a lot of assets, this person could weather the storm of getting through the 5-year period, let's say, and potentially with the help of children as well. Or this is a person who has lots of income and they have a very robust long-term care policy. So we've talked about that. Now, the next example, I will say, the never Medicaid client. So this is a person who is more than just modestly wealthy or middle rich. This is a person who we can almost kind of assure is probably never going to apply for long-term care Medicaid, but yet they see advantages in this trust. And that's one of the reasons, for those of you that have hung in there with me through this presentation, this is one of the reasons I brought this presentation to your attention today. I sat with a client recently who had $9 million and another client that had $12 million of assets. And these people obviously are above a moderately wealthy person. And they still see the advantages of wanting to set aside certain assets for their children during life, but yet being able to have this modicum of control. So this is a person who is never going to apply for Medicaid, whether they have 3 million, whether they have 9 or 12 million, but they still see advantages in using this particular trust design. The next bullet point before we wrap up with examples is I promised mom and dad. So many times we will have a client who says, I am doing my own estate planning, whether I'm married or single, but my parent recently died and they left me an inheritance. I don't think I'm ever going to apply for Medicaid, but I want to make sure that this particular chunk of money, whether it's $500,000, whatever it is, I want to make, or this property, I want to make sure that property is set aside and we start that 5-year period for that particular asset because I promised my parents that I would never lose this money or I would never have this spent down for Medicaid. So that's an example of one of the tools or uses of this trust. And then my last example is something that you will occasionally run into. And this is someone who doesn't necessarily have a lot of income or personal assets except for real estate. And I've run into this several times where someone is not necessarily cash or investment wealthy, but they have 2, 3, 4, maybe even 5 rental properties, and they are aging, and they don't have a lot of assets to pay for long-term care, but they want to keep these rental properties in the family. So these Medicaid type 5-year trusts can be used to try to preserve assets in that particular case, where the family wants to preserve those rental and income producing properties for future generations. And I would say that's not what these trusts were really intended for, but they can be used in those contexts. So it's about 17 after the hour. That was a good hour and 15 minutes of Medicaid 5-year trust information. I hope that you've been able to take something away from this that you can use, that you can recognize certain needs that clients bring up or goals that clients bring up, and that you can see past the name of this trust, the Medicaid Asset Protection Trust, which I would prefer to call the 5-year hybrid trust. And of course, there are many variations of trust, but this one is one that was designed and refined over the years and seems to work well in the long-term care context, but it also can work in other contexts. And if we can be available to you, I'm going to go to my next slide. If we can be available to you to answer questions or field questions, or if you're dealing with other attorneys that are trying to put these trusts together, many times we are asked questions about how to design these trusts from other lawyers, and we're happy to help in trying to do the right and best thing for clients. So thank you again, Jeff. I'm going to turn it back to you for any questions, and I thank everyone for hanging in there through some pretty dense information.
Thank you, Steve. Great presentation as always, a lot of substantive information in there. Steve's contact information is on the next slide there, along with mine. So as always, you can reach out to us with any questions or thoughts that you may have. We're always looking to collaborate with advisors to be resources and find ways that we can best serve clients together. If we haven't met you before, or if it's been a long time since we've met in person, we'd love the opportunity to get back together with you or meet you for the first time. Again, to learn how we can best serve clients together, which is such an important thing. So thank you, Steve, and thank you to everybody for being here today. A few things, now would certainly be your time to get any questions that you have in for Steve. He'll be happy to answer anything that you have to pass his way. As far as our webinar series, we have a few really good presentations coming up. As Steve alluded to earlier, tomorrow we have our popular quarterly trustee selection and how to choose the right one for you. And that will be at 10 o'clock tomorrow. And on Friday the 2nd, we will be doing what families need to know about planning for a loved one with special needs, one of our more popular presentations we offer on a recurring basis. And then on Wednesday, June 7th, we have special guest presenter Eric Jorgensen, a very well-known special needs planner and consultant with True North Disability Planning, talking about putting it all together, a diagnosis to adulthood guide of navigating the disability world. And he's offered that presentation with us a couple times over the years, and always a wealth of information and just a great all-around guy. So look forward to seeing you there. And as I always mention, most every one of our presentations does offer continuing education hours. So if you need them, we have them. So feel free to register for those presentations, and we'll look forward to seeing you again. So let's see, we do have a question here that's come through. From our friend Joe Steve, who we know. Thank you, Joe. And the question is, do you see an advantage to using an annuity with long-term care features as a safety net in case of need for long-term care before the 5 years have elapsed?
Yes, definitely. I would say thank you for that question, Joe. Any kind of hybrid or policy that is a benefit that is attached to life insurance or an annuity, absolutely. Anything that is a tool like that will give peace of mind and kind of, in a way, guarantee that we can get through the 5-year period. And that's what so many people want to do but don't know how to do it. So yes, absolutely.
Okay. And I had a question about the date for that special needs presentation. If I wasn't clear, I apologize. It is Friday, June 2nd. So that'll be next Friday at 10 o'clock. And I'll be sending in your continuing education hours tomorrow morning. So please be sure to get your IDs, if you have one, into me before then, please, so I can get those in to the CFP Planning Board of Standards and get your certificates out as well. I'll also be sending out the video for today and some follow-up information for you, as I always do, first thing tomorrow morning. So let's see if we have any further questions for you, Steve, and then we'll call this a success. Looks like that is it. So thank you to everybody for being here. We appreciate your support of Elville & Associates on our Advisors Forum and webinar series, and we look forward to hosting you again soon. If we don't see you, have a happy Memorial Day weekend, and we will talk to you again soon. Thanks very much.
Thank you.